He took steroids, and he took many other supplements.
He had a lot of things in cabinets and on the counter and stuff.
30 pills a day.
Yes.
He has his own cabinet for that, right?
Of course.
Compelling defense witnesses in the Ponzi scheme murder trial. Natalie Cochran's family testifying that her husband was obsessed with steroids and in bad health. So now we're looking ahead to what the defendant needs to say when she takes the stand. And singer Chris Brown suing Warner Brothers for, get this, $500 million, saying that he's being unfairly labeled as an abuser. So we're asking the question, how will a jury see him? Also this hour, we're breaking down the big takeaways from Kouri Richins' hearing. Defense attorneys for the accused killer and children's book author want some very important evidence tossed out. Plus, more critical evidence on the brink, this time in the case of Bryan Kohberger. His defense team is fighting to get DNA evidence excluded from the case, and that would certainly tip the scales of justice. It's all coming up next for you right here on Opening Statements. TGIF. Good Friday morning, my friends. Welcome to Opening Statements. I'm Julie Grant. It is time for some coffee and court. We got a big day ahead and a big show planned, so let's get to it. Go ahead, grab that cup of coffee right now. It's time for my opening statement. Is the case a stinker? Is the case against rapper A$AP Rocky a stinker? My friends, I'm pondering this question this morning because I know that he passed on a sweetheart plea deal. 180 days in jail, not prison, jail, for a guilty plea to assault with a semi-automatic firearm. That is a great deal. If Rocky's convicted, he could do some serious prison time, up to 24 years. So why run that risk? It's either one of two things. He's innocent and he didn't do the shooting, or he's confident the state won't be able to prove it. It's one or the other. And that's why I'm wondering, is this case a losing one for the prosecution? So I know that the alleged victim gathered the spent cartridge casings himself and turned them into police. That could be problematic. I also know that on the surveillance video of the shooting itself, it may be hard to identify the perpetrator. But on the other hand, seems very strange to me that A$AP Rocky would carry around a prop gun on the day of the shooting, as his legal team is saying. And the prosecutors weren't buying that story about the prop gun either. They called it an ambush, a brand new defense presented right before his trial is set to begin. So, my friends, I'm reserving any judgments until I see the case evidence. But in the meantime, you can see why I'm wondering why a successful rapper like A$AP Rocky is taking his case to trial. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
Actually, done.
Okay, fine.
Done. Because you're costing me money. I didn't do because I got to this house because of you.
You let Mom say some line
No, because of you. Flirting with like 3 girls the whole time.
3 girls.
You know who that is? We've got defendant Courtney Clenny, the former OnlyFans model, in court for a big motions hearing today. That one's going to start up at 9:30 a.m. Eastern Time. In California, we have opening statements beginning in the celebrity stylist murder trial for Monica Cementilli. She's facing murder and conspiracy charges in connection with the death of her famed hairstylist, Fabio Cementilli. That one starts up at noon. And in Ohio, we have got defendant Billy Wagner. You know him from the Pike County Massacre case. He's one of those defendants. Well, he's going to be in court at 10 a.m. This is a change of venue hearing, so this should be very interesting. As you know, that case has gotten international attention. Now, let's turn to our top story, my friends. Defendant Natalie Cochran expected to testify next week in the Ponzi scheme murder trial, and we really saw a different side of her when her kids took the stand on Thursday. Look at her. She was seen getting very emotional. There's no court today due to some scheduling issues with defense witnesses and them being unavailable today, so it'll start back on Monday. But Court TV's legal correspondent Kelly Croft explains what we can expect next week.
Good morning, Julie. Court is dark today. Defense counsel has 3 medical experts that will be called. They aren't available till Monday, so today jurors have the day off. Thursday's proceedings were quite emotional. Several of Natalie Cochran's family members testified for the defense. Natalie wiped away tears during their testimony. Cochran's daughter testified that her father took steroids and dozens of pills each day. Defense counsel asked her if her dad liked going to the hospital.
Did he like to go to hospitals?
No, he hated them.
What did he tell you about these hospitals?
He considered them to be a waste of his time and that he never wanted to be in one again.
Cochran's 17-year-old son, who we couldn't show on camera, testified that his dad was the person in charge of the business.
Was your father somewhat secretive about his business?
Very.
Obviously wouldn't discuss it with a 13-year-old or 10-year-old on the business level of the MBA and his associates, but what did he tell you about his business?
That the business had to be a woman-owned business so they could get more contracts. I think we all know who wore the pants in the situation. He definitely ran it way more than she did.
Now, next week, when things get rolling again, the 3 medical experts will be called. And then, of course, Natalie Cochran is going to be testifying in her own defense. Julie, we'll send it back to you.
All right, let's talk about all of those things right now that Kelly just shared with us. I'm going to bring in our legal eagles, criminal defense attorneys and former prosecutors, Joe Tamburino and David Bruno. Good morning to you both. Joe, let me start with you, please. When we think about what the kids might have done for this case, I want to get your thoughts, please.
Good morning, Julie. Thanks for having me on. I think they really helped the case. I think they did a few things. Number one, they certainly humanized her. There's no doubt about that. Some emotions came out. They didn't look like crocodile tears. It looks like she was obviously affected by their testimony. Number two, it helped them factually because it got them to say, hey, my dad, he takes these things. This is what he likes to do with bodybuilding, so on and so forth. And three, it was the best evidence so far that the victim, Michael, knew what was going on with the business. I mean, you heard some of that testimony that you replayed, which is, they needed a woman as the front person. Why? Because in a lot of government contracts, the government tries to get minorities and women to get these contracts, not a regular white guy. So, it shows that he's involved in all this. So I think the testimony greatly helped the defendant.
Sure. Excellent points, Joe. Thank you. I want to play that clip where this is really a moment where the daughter is on the stand talking about seeing her father taking 40 pills a day. Let's take a look at Nicole Cochran together now.
He would lay all of his pills out on the counter, and there would be so many of them that they would just sit in a whole circle, and it looked like the size of a dinner plate. And then he would scoop them handfuls at a time into his mouth and use the sink water to drain them down. And then he would take the steroids as well.
How many pills were there, just roughly?
Probably around 40 a day.
Oh, that was a moment. David Bruno, I want to get your thoughts on the kids, please.
Powerful testimony for the defendant. I mean, unbelievable, because he took my notes. Exactly. I mean, what they bring to the table too is the health issues that he was having, all these ingested pills. Also, his sister testified about observing an injection with a syringe, which could be at issue for the insulin. We know that there's medical testimony coming up to challenge the cause of death. And then also, I really wonder, here's the biggest question that I have right now. How is she going to deal with the friend that came in to say she got the insulin? Right. Because if I predict that she's going to probably say that he wanted it, that he needed it, that he asked for it, he was injecting himself, because that's what she really has to deal with about that insulin, because that's what the prosecutor says is the murder weapon, so to speak, and she's got to distance herself from that if that's the insulin cause of death.
Ooh, I like that theory, David Bruno. So let me ask you a follow-up on that. How do you think she might deal with it when they'll be able to catch her in a lie if she says that, you know, she was administering it. We know she already denied that to officers. We know she denied that one bottle in particular that she said was there for a neighbor. How do you think she should clean that up if that's the way she wants to go, that he wanted it and she helped him?
Yeah, that's the cross. It's the prior inconsistent statement to challenge the veracity of the particular statement. But let's just see how she does on the stand. I mean, can she articulate? She's humanized. Her kids came forward for her. That means a lot to juries. This reminds me, too, of the Murdaugh case in a sense that we have the Ponzi scheme. She's already going to fall on the sword on fraud, and she's going to have to convince this jury that she had nothing to do with the murder. It did not work out very well for Mr. Murdaugh, but she's got to have to deal with similar issues because of the prior conviction.
Yeah, great points, David. Thank you for that. Let me play another clip. Let's listen to her son testifying and watch how emotional Natalie Cochran gets.
After your father's death, what was your mother like?
I feel like she was very strong.
She still did her business. She still did her business, true?
Yes, sir.
Was she brokenhearted because of the death of her husband?
Very. We all were.
Okay, so Natalie Cochran's expressions have become somewhat of a talker for all of us watching this trial, as you both know. Joe, let me go to you on this. What do you think we can expect from her when she takes the stand? How does she need to present herself, and what are the key things that she needs to convey?
Well, there's three things she has to explain. Number one, why did she get insulin from Davis? Number two, she has slight variations in the three statements she gave the police, so she has to clear up some discrepancies. Were they home together before Michael supposedly passed out in the kitchen, or were they apart? So there's some discrepancies. And number three, the biggie, why didn't she call 911? She's got to explain those three things. Now, what you and David were just talking about, well, why did she get the insulin? It's going to be really difficult for her to get up there and say, I got it for Mike. Why? Because they never mention that in opening statements. Now, opening statements are not evidence. Everybody knows that. What the attorneys say is not evidence. But if you're a defense attorney and your main defense is your client is telling you, look, I got the drugs, I got whatever it is, to give it to this person, the victim in this case, boy, you got to lead with that in opening statements. So she's going to have some explaining to do. Also, she's going to have to go through a cross-examination where if the prosecutor is on the ball, they're going to argue to her that she is an actress. She's a con man. She puts on a show. She bamboozled all these people with her con game. So she knows how to present herself. She knows how to get the con going. So she's going to have to look out for that, too.
Yeah, really great points. Joe, thank you for that. Here's what we're going to do. We're going to leave it here for now. But of course, we're continuing following this case, and both sides get some time to regroup before the jury returns on Monday to hear more evidence. Joe and David are sticking around. We want you to do the same at home, please. Here's what's coming up next.
Where are you headed?
Well, we're coming from WSU.
So you're coming from Washington State University?
Yeah.
And you're going where?
We're going to be going to Pennsylvania.
Oh, okay.
Bryan Kohberger's defense team is asking for nearly all of the evidence to be thrown out. But first, Chris Brown is going after Warner Brothers in a multi-million-dollar lawsuit.
Grieving widow or mastermind behind a murder.
Monica Cementelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cementelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder.
It's a whodunit Hollywood story. But will there be a twist that no one sees?
The celebrity stylist murder trial. Today, only on Court TV.
Be warranty.
Welcome back. The trial for hip-hop star A$AP Rocky is what's trending in true crime this morning. Opening statements kick off today. The Grammy-nominated rapper is accused of shooting at a former friend near a Hollywood hotel back in 2021. Rocky's real name is Rakeem Mayers, and he declined a plea offer to spend 180 days in jail ahead of his trial. He faces a maximum sentence of 24 years in prison if he's convicted. Let's take a look at the jury breakdown. We've got 12 jurors who are going to hear this case. 5 of them are men, 7 of them are women. According to TMZ, none of the jurors, including the 4 alternates, are African American. None of them. And we know the defense was taking issue with the pool earlier this week. Now, the defense team plans to call witnesses to testify that the alleged firearm seen on security footage, alleged to be carried by Rocky, was a starter pistol he carried as a prop, pointing to why no shell casings were found at the scene. The surveillance footage is grainy of the actual shooting, maybe hard to identify the shooters wearing a dark hoodie, hard to see the face, and we know that the alleged victim collected the spent cartridge casings himself and brought them to police, which could prove to be problematic. So if you saw my opening statement, you're going to know what we're asking. We're wondering, is this trial going to be a stinker? In other words, is this a bad case for the prosecution? Maybe, maybe not. Let's see what our power panel thinks. Let's bring back in criminal defense attorney and former prosecutor Joe Tamburino, and welcome in domestic violence expert and former law enforcement officer Claudia King, and media personality and artist Head Crack. Good morning to you all. Okay, is this one a stinker? Ladies first. Claudia King, what do you say?
It definitely sounds like it, Julie, because the prosecution made that offer of 180 days in jail. To me, that shows that they don't have a ton of confidence in this case if they were going to let it go for just 180 days. It sounds like the video is blurry. It's hard to tell if it's really A$AP Rocky. There's the issue with the shell casings and the fact that the victim turned them over and collected them allegedly. So I just see this being very problematic for the prosecution.
Yeah, great points. Claudia, thank you. Great point about the plea deal. When you have such a sweetheart deal, could mean that, you know, the case stinks. Head Crack, I want to go to you next, please. Your thoughts on this? Is this a stinker or maybe a solid case?
It sounds a little sloppy, and like what she was saying, if they're gonna offer you 180 days, which is way sweeter than 24 possible years in prison, and you decide to be, like, I like our odds on this, and I'm just gonna go for it because we know what we know. I think the defense probably feels like they have a very fortified, defense on their side that'll be able to prove that A$AP Rocky wasn't trying to really hurt this man, but just scare him off, fend him off, or whatever. And it's just so problematic from the prosecution side.
All right, Head Crack, I like what you said about sloppy. You said this seems sloppy. Head Crack, I think you're right. I think that this is going to be a little bit of a mess when it goes to trial, and the defense already getting the prosecution fired up. They dropped this little bomb this week about saying it's a prop gun, not a real gun, because he's seen on video holding what looks like a gun. And so they're saying, no, not real. And the prosecution's saying they've been ambushed by the defense with this new theory. Joe Tamburino, last but not least, want to get your thoughts on all of this, please.
2 things. First of all, it's highly problematic for the prosecution that the alleged victim finds the evidence. So the police are there. Police are crime scene people. They're going around the crime scene. They don't find any shell casings. But it just so happens hours later that the alleged victim says, gee, look what I found. So that's highly problematic. Also, we don't know if they searched A$AP Rocky's house. Can the prosecution show that this guy even has guns? Has he ever had a 9mm? Does he have some other type of firearm? So I think that whole thing is problematic. Second thing, this whole called ambush with the new theory that he had a prop gun. The defense doesn't have to disclose their theory. Yes, they have to disclose witnesses, just like the prosecution, but this whole idea of ambush is nonsense. The defense doesn't have to say a word. The defense could have a theory one day and a second theory the next day. So this whole idea of ambush, yeah, it's good PR. It's something that you're going to give to the media, but it's nonsense.
Joe, really great points. Thank you for all of that. Head Crack, let me go back to you, please, for the sentiment of the industry. What is the sentiment? Are other artists kind of rallying around him? Is there a showing of support for him or not so much?
You know, it's one of the more quiet cases that we've heard about in a while. Like, it's one of those things you hear about, it's a blip in the news, and then it goes away, then it comes back, and of course it's going to ramp up because the trial's getting ready to start. But, you know, A$AP Rocky has a lot of friends in the business, and then, of course, because, you know, he's booed up with Rihanna, you're also going to get a whole bunch of other people that are going to be rallying for him on the strength of her. You know, shout out to the Rihanna Navy. I'm a member. So at the end of the day, A$AP Rocky has, you know, for the larger part of his career, been a very non-problematic guy. I know he did have some issues overseas a few years ago, but, you know, he did his time and he got out. And, you know, and he's been trying to just be the best dad he could be, get back to the music and continue to serve his fan base and, you know, and pop up in fashion ads where he can, because he is the fashion killer. If you know, you know.
He really is. I know. I feel like so many of us maybe know him more for fashion, him and Rihanna, too. I mean, you know, my gosh. I mean, I think she's got 9 Grammys, too. Not taking anything away from that. But, yeah, I mean, they're a power couple for sure. Maybe we'll see her. We sure hope. But I like what you said there, Headcrack, about he hasn't really been known as being a problematic guy. That's not A$AP Rocky's reputation. But with the next person we're going to talk about, that's debatable. Chris Brown is also trending this morning in the world of true crime because he filed a $500 billion lawsuit against Warner Brothers Discovery, saying that he was falsely labeled as a rapist and an abuser. Okay, so many of us know him for his hit songs, but the docuseries is titled Chris Brown, A History of Violence. It's been out for a while, and the allegations come from an unnamed woman who says that Chris Brown raped her on a yacht outside of Diddy's Miami home. Chris Brown's attorney tells TMZ that Brown has always denied that claim and that Brown provided Warner Brothers Discovery with proof that the woman's claims were false. Now, an Investigation Discovery spokesperson tells People magazine, quote, "We stand behind the production and will vigorously defend ourselves against this lawsuit." The lawsuit pointing out that Brown has never been convicted of any sex crimes. So the question we're wondering this morning, if this one goes to trial, let's just say for the sake of our analysis that it does, is that jury going to sympathize with Chris Brown? Claudia King, I'll go back to you, please.
That is a tough one because, as you were just talking about Rihanna, we all remember those pictures, and that was a long time ago, but that's in all of our heads. Now, that being said, these sex crime issues are a totally different story. There are issues with that alleged victim. There were apparently text messages that police found that discredited her story several years ago when she was suing Chris Brown herself. So, you know, I think that's where there could be the issue, is with the sex crimes. So people are going to remember the Rihanna photos, the jurors might. So the defense or the prosecution, the Chris Brown, is going to have to work hard to get that out of their mind and really focus on this alleged victim who has holes poked all through her story.
Yeah, great points, Claudia. Thank you. You know, when we were having a discussion about this in our newsroom, people are split. You know, some people were saying they can't look at him and not think of what he did to Rihanna. And then others were saying, you know what, I've moved past it. He did his time. He owned up to what he did. He pleaded, and he shouldn't have it hanging over his head forever. Headcrack, I want to go to you next, please. Your thoughts on him?
I mean, here's the thing about Chris Brown. This Rihanna situation that took place in 2009 is kind of like a cold sore that continues to reappear anytime Chris Brown tries to move on with his life, do something, anything to move his ball forward. And listen, he did the apology tour. I think he seeked counseling. He's been largely not in trouble since the Rihanna situation, but when people bring it back to the front of mind, it makes it seem like it just happened a couple months ago. And so like she was saying, it's going to take a lot to get that out of people's heads because, yeah, those pictures are haunting. And anybody who's ever been a part of a domestic situation or been physically abused, that triggers them. So that puts that energy into making sure they put this guy somewhere else. But he has no prior sex crimes. And here's the thing. With this documentary being out there are people who have seen it, already forged an opinion, and if it comes out that the girl is lying, they're not going to delete the documentary. It's going to be there forever, and the damage has been done.
Really good points. Head crack, thank you for that. Especially, I like the cold sore analogy to him. You never know when it's going to pop up, but people just can't stop seeing it. When it does, it is problematic for him. Okay, Joe Tamburino, being our legal eagle on the panel, what do you think if a civil jury were to be picked and were to actually hear this case? What do you think they might think about him?
I don't think they're going to think well of him, and I think he's got an uphill battle. I mean, there's so many interesting things about this case. Number one, when you sue for defamation and you say, you harmed my character, you harmed my reputation, okay, your reputation wasn't great to begin with, so how much damage do you have there? Number two, when you say that, you open up your whole life. So that means, you already mentioned he was at this Diddy party once in 2020. Diddy is toxic. You don't want to mention his name in a courtroom right now. So he's got that problem. Number three, that he is a public figure, so he has to prove that Warner Brothers did this with malice. And Warner Brothers is going to come back and say, look, we're going to rely on truth as a defense. And this whole thing about, well, she was discredited, there's only one group of people who could make that decision. That's the jury. So, they could say all they want. Well, she's been discredited. We have these texts. We have these evidence. That's all fine. Bring it to the jury. But I think he's going to have an uphill battle to prove his case.
Really excellent insight, Joe. Thank you for that. You and Claudia are able to come along with us. Head crack, you're a busy guy. We got to let you go, but we appreciate your time this morning. I'm going to tell everybody during the break, go get Head Crack's new album, Microdose. Go download it. You got 4 minutes. Do it right now. Head Crack, thank you. See you soon. Peace. When we come back here on Opening Statements, we're turning to Kouri Richins' case. She's back in court, and her defense team wants some big evidence tossed out. And Bryan Kohberger's defense team looking to do the same thing. We'll talk about how it's tipping the scales. Welcome back. It's been almost 3 years since Utah father Eric Richins died from a fentanyl overdose, allegedly at the hands of his wife. This morning, we're giving a voice to victims like Eric as we update the case against his wife, Kouri. Now, Kouri was back in court on Thursday as her defense team asked the judge to suppress key evidence, including electronic statements and data that were made to police. During the hearing, we hear audio of Richins talking to a deputy after she was pulled over 1 year after Eric's death, and Richins didn't know that she was being recorded.
Does that mean I'm arrested for something?
No, you're not arrested.
I don't know why it's happening.
Okay, if we could stop there for just a minute. So what looking at the transcript, it appears that what she just said was, and I know you could kind of hear it a little bit, but she said detained. Does that mean I'm arrested or something? So had you told her when you first brought her in the car that she was detained briefly?
I told her that at the window.
So she's following up and saying, detained, does that mean I'm arrested for something? And you responded, no, you're not arrested, right?
Correct.
Now, during that encounter, Richins gave her cell phone to a deputy, and the defense team is arguing that phone was seized illegally because the search warrants didn't authorize searches of her car. Now, the judge has not ruled on these motions yet. They were just made by the defense team yesterday. And by the way, you're going to see all of it today. We're going to show you everything we weren't able to air on Thursday. This is a really contentious hearing. So let's talk about it. Let's talk about what the defense wants to suppress. I want to bring back in Joe Tamburino. Bruno and Claudia King. So I want to show it to you. They want to suppress Kouri Richins' statements to police. They want to, oh, I'm sorry, I'm bringing in attorney David Bruno. Forgive me, I'm bringing in the wrong person right now. David, forgive me, don't be mad at me. All right, so I want to show you both what is being asked of the court to keep out. So we put it together here. We've got her statements to police, we've got electronic data, a notebook taken from her home, and that walk the dog letter found in her jail cell, which they claim contains privileged attorney-client communications. As I recall, that was part of a notebook too. Now, Deputy Jamie Wood was asked about taking Kouri's cell phone on the day that that search warrant was executed on her home. Let's take a listen to what the officer said.
And you ask her, do you have a phone with you? Is that right?
Correct.
And this is when she's still sitting in the car being detained, right? And then she answers, I have my phone, yeah. And what do you ask her?
I ask her, is it in your pocket?
And what does she say?
She says, we have phones. We have no, it's in my car.
It's in my car. Okay. So there's really no dispute that at the point she's sitting in that car, it was not on her person, correct?
Correct.
Okay, so the warrant is for the house. They want to get the phone as part of that, but the phone's in the car. They don't have a warrant for the car. David Bruno, do they have a legal problem here?
Potentially, okay? Because, the state, it's state by state, and it really does depend. But I see this as a consent search. And what that means is, while they didn't have the warrant, there is another warrant exception that is consents. You can go get it. However, at least in my state, you have to be advised of certain things, like you have the right to refuse, and it has to be voluntary, and this is a fact and circumstance where she wasn't Mirandized. So just taking a step back from this case, I mean, this is the police tactic of trying to secure evidence, get information. They didn't Mirandize her because they're trying to curry favor. And it is a very, very interesting argument here that this is a violation of the Fourth Amendment, but does it rise to a level of consent? That's going to be really the issue for the court.
I love that explainer you gave us, David. Thank you. Because if she goes and gets it and willingly turns it over, is it a problem? I see what you're saying. Thank you for that. And you hit on something else I wanted to bring up with Claudia, that issue of the officers not giving her her warnings pursuant to Miranda versus Arizona. I've got a clip of the officer testifying about that. Let's take a look.
Do you want to come with me and grab your phone real quick? Is that right?
Correct.
All right. Prior to that, did you ever give her her Miranda rights?
I did not.
Did you ever tell her that she had an option whether she cooperated with you or not?
I don't believe I did say anything like that.
Ooh, okay. Claudia, what do you think of this? So that was the officer that apparently escorted her to her car to get that phone when the other officers are in the house.
I feel like it's such a gray area because she wasn't actively questioning Kouri Richins, but she may have felt like she was being held. She was not free to leave. So I do see an issue there, and that is why today most police departments will say, just Mirandize everybody. If you are going to ask them any sort of question, go ahead and Mirandize them. That way it's done. That way there's no question when it gets to court and you're not even dealing with this. So I think there could be a potential issue with her not giving that warning. And then even though she asked Kouri to go get the phone with her, Kouri can argue that, well, I was being detained. I felt like I was not free to leave. I wasn't told I was free to leave. So I felt like I had to do what the officer told me to do.
Claudia, such helpful insight what you just shared, that departments are really trying to go the other direction nowadays. Like you said, when in doubt, just do it, give the warnings. Because of, as you noted, the gray area. We know that we need interrogation to trigger Miranda, but that's always up for debate with clients, isn't it? David Bruno, I want you to weigh in.
Can I comment just real quick on that?
Yeah, I want you to,
because I think this is a confusing issue in a sense that Miranda's there for the admissibility of the statement. it has really not much bearing on the securing of evidence. So when they Mirandize, it's really for the protection of any confession or admission that comes subsequent to the Miranda warnings. So really, when we talk about evidence, it's Fourth Amendment, and statements in Miranda's Fifth Amendment. So when we talk about the securing of evidence, it's really the reasonableness, because the Fourth Amendment prohibits unreasonable searches and seizures.
Yeah, exactly right. David, thank you for that. And yeah, so apparently one of the other things, I know we're talking a lot about the phone, but yes, her statements, they want to keep them out, everything that she said. And generally we think of, I'm going back to law school, David, I think of my professor, I can still hear him saying custody plus interrogation equals Miranda. And so here, do you think this could get tricky with whatever came out of her mouth? Because as Claudia noted, she's not detained, but maybe she didn't feel free to go. What do you think?
Exactly. Okay, so custody is defined as a reasonable person would feel they're not free to leave. Interrogation is a statement that would elicit an incriminating response. So they don't have to be in cuffs. They don't actually have to be detained, like told they're detained. It's what does a reasonable person feel in that same situation? And certainly, I think most people would have felt that they're not free to leave when there's police in the house, they're securing a search warrant, there's police around. So that gets you to custody, even though there's not handcuffs. And then the next question is, what was asked of her? And is it reasonably likely to elicit an incriminating response? So that's the two-step analysis for that particular issue.
I love it. David Bruno, thank you. Great law school lesson this morning for all of our courties. David and Claudia, thank you both for your insight and expertise on this one. Claudia, I know we have to let you go. We'll see you very soon. Thank you for everything this morning. And be sure to check out Claudia's podcast, Strong Enough. And as we go to break, we want to remember the victim in all of this, Eric Richins. He was a devoted father of 3 beautiful boys. He was also an avid outdoorsman who loved his family unconditionally and was very successful as well in his career. Take a look at his picture as we head to break.
Grieving widow or mastermind behind a murder.
Monica Cimentelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cimentelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder.
It's a whodunit Hollywood story. But will there be a twist that no one sees?
The celebrity stylist murder trial. Today, only on Court TV.
All now.
Now for what's tipping the scales of justice in the Idaho student murders case for defendant Bryan Kohberger. He's going to be back in court today for day 2 of his all-important motions hearing. His defense lawyers are asking the judge to throw out most of the evidence in the case because they say it all hinges on an unconstitutional genetic investigation process. Kohberger's lawyers also argue that the search warrants were tainted by police misconduct.
When Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either.
All right, in this segment, I want to focus on that trash pull. And these are the beautiful victims who were killed in November of 2022. And so the defense team here is trying to get out. The biggest thing is the DNA that came from the knife sheath, the trace DNA that was left on the snap, comparing it to a trash pool and DNA obtained at the Kohberger home, and they found what was on the knife came from the spawn of Papa Kohberger. And so the defense team is saying this is unconstitutional. The genetic genealogy testing that the state done, unconstitutional. Okay. Let's talk about that, because if it's excluded, does the case fall apart? Let me bring in our brilliant legal eagles, David Bruno and Joe Tamburino, to talk about this. Okay, so the unconstitutionality, so they say, of what was done here. David Bruno, what do you think about that?
We're back in the Fourth Amendment. Reasonable. Right? What is reasonable? What is not? And when we're talking about this garbage, when we're talking about databases, we always have to talk about the expectation of privacy. And that is really relevant here. You know, traditionally and historically speaking, when you put garbage out at the curb, you do not have an expectation of privacy when you discard that particular property. On the issue of these databases, the question's going to be, well, what was in the databases? How did they get those profiles? And did the people know that they were giving up sort of their rights? When people submit DNA and they're trying to get those lineages and those histories and things, there are a lot of provisions and you're waiving a lot of rights. And it really is fact sensitive on what databases they went into, because what we're talking about is the DNA on the knife sheath. And that essentially is the smoking gun. If they get that in and they can prove that Kohberger's DNA is on the knife sheath found under one of the bodies at the crime scene, that's game over. So the question becomes, I mean, that DNA sample that's there in the crime scene, there's no expectation of privacy to that. They're doing the DNA on that. And then it's the comparisons is really what is at play for the Fourth Amendment. The reasonable, was it reasonable? And also expectation of privacy. I think the government's on pretty firm foot on both those questions.
David Bruno, I think you should get some CLE credits for all the teaching you're doing this morning on this show. Thank you for that. Speaking of the expectation of privacy, Joe Tamburino, I know you've got a lot to say about this. Apparently, the court thought Mr. Kohberger deserved some privacy. Yesterday, the judge had closed off part of the hearing from the public. Our courties were very disappointed, and then allowed the public to see the other half of the hearing, making everybody wonder, well, why was it we couldn't see all of it? Curious what you think about that ruling.
What I think is it's a wrong ruling, and media organizations should sue, because you can't just close a courtroom. I mean, federal law, state law, but mostly federal law under the First Amendment, we have open courtrooms. Yes, in certain juvenile cases and things like that, but 99% of the time, you just can't shut the courtroom doors. And the judge did it under this theory of, well, we're going to be talking about evidence that if it gets out there, it could taint the jury, a future jury. Well, if that's the reasoning, then you would basically close every criminal hearing before trial, because of course you're going to hear evidence that might not be admissible at trial, and some potential juror could hear it. That's why you go through jury selection. You try to weed out those people. So closing the courtroom is ridiculous. Additionally, it violates Idaho's victim laws. A victim has rights. A victim families have rights in Idaho, as with all states. And 19.5306 under Idaho law says that victims can be in all court proceedings. Actually, in Idaho, they say they could be even in juvenile proceedings. So we have a violation of open courtrooms under the First Amendment. We have a violation of a victim's rights. And I think, I mean, if that happened here in Minneapolis, media organizations here are very active, especially since the Chauvin trial years ago. There would be a lawsuit to get those courtroom doors open.
Boom. Drop the mic. Joe Tamburino, you deserve CLE credits too for all of that legal presentation. Thank you. Yes, and I'm sure our courties at home are applauding that too, because we want to see it. We want to see what's going on with this guy. So we'll leave it here for now, but he's back in court today. We've got another Kohberger hearing today, so that'll be later on Court TV Live. Joe is coming along with us for some Court TV Live. We got to say goodbye, and a big thank you to our friend David Bruno for everything this morning. Have a great weekend, David. We'll see you soon. And that is all for this episode of Opening Statements. You can watch it again, though. You can share it, tell your friends about it, invite them to have some coffee in court with us weekday mornings at 8 a.m. Eastern.